Supreme Court issued emergency ruling May 12, 2026, eliminating gun permit requirements nationwide. The court just ruled requiring government permission to exercise Second Amendment is unconstitutional, striking down permit systems in all 50 states and establishing constitutional carry as federal standard. By the end of this video, you will know all the implications. So, let's get into it.
An extraordinary 6-3 emergency decision, conservative majority held Second Amendment is constitutional right that cannot be conditioned on government-issued license, invalidating shall-issue permit systems even in states that complied with Bruin. Justice Alito writing for majority. The right to keep and bear arms is not privilege granted by government. It is pre-existing constitutional right. Government must respect. Requiring citizens to obtain permit, pay fees, complete training, and wait weeks or months to exercise constitutional right imposes unconstitutional prior restraint. Emergency ruling came in response to California's post-Bruin permit system, requiring 18-hour training costing $400-600, 4 character references, in-person interview, and $6 12-month wait that plaintiffs argued made permit effectively inaccessible despite being shall issue. Subscribe, because this emergency shadow docket ruling represents most dramatic expansion of Second Amendment rights, fundamentally changing how all 50 states regulate firearms and what you must understand about immediately exercising constitutional carry rights. After Bruin 2022 struck down New York's proper cause, blue states implemented new shall-issue systems, creating massive barriers through fees, training mandates, interview requirements, and processing delays. California's AB 2847 required $150 application fee, $300, $600 mandatory training, 4 character references with in-person interviews, applicant interview including psychological questions, fingerprinting and background check taking, 2 to 4 months, total processing, $6 12 months. Firearms Policy Coalition filed emergency application arguing this violates Bruin by creating permit in theory only where costs $450, $750, time 18 hours plus interviews, and delays 6 to 12 months make permit inaccessible to working class. Supreme Court granted emergency stay, then issued full ruling striking down all permit requirements. Let me break down what court held, which permit systems eliminated, legal reasoning behind decision, state-by-state implications, and what this means for gun owners immediately. Number 1, what Supreme Court held. Core holding. Second Amendment protects pre-existing constitutional right existing independent of government permission. States cannot condition exercise on obtaining government permit, regardless whether shall issue or may issue. Any permit requirement constitutes unconstitutional prior restraint. Constitutional carry is federal standard. Justice Alito. No other constitutional right requires government license before exercising. We don't require permits to speak, worship, vote, assemble. Second Amendment is no different. States can prohibit dangerous persons from possessing firearms, felons, mentally ill, domestic abusers, but cannot require law-abiding citizens to seek government permission. Permit systems impose unconstitutional burdens. Fees create wealth barrier. Training mandates consume time money working class cannot afford. Waiting periods delay right when needed most. And requiring government approval treats constitutional right as privilege. Constitutional carry is constitutional command. Why 6-3? Conservative majority. Roberts, Thomas, Alito, Gorsuch, Kavanaugh, Barrett held permits unconstitutional. Liberal justices, Sotomayor, Kagan, Jackson, dissented, arguing Bruin only struck down subjective may issue and states should be allowed objective shall issue permits. Majority rejected. Constitutional rights cannot be licensed even through objective system. Number 2, which permit systems eliminated? Shall issue states, 25 states. CA, NY, NJ, MA, CT, RI, MD, DE, HI, IL, MN, or WA, MICO, NM, NV. Concealed carry permit requirement eliminated. Citizens can carry concealed without permit. Permitless carry states, 29 states. AL, AK, AZ, AR, FL, GA, ID, N, IA, KS, KY, LA, ME, MS, MO, MT, NE, NH, ND, OAK, OK, SC, SD, TN, TX, UT, VT, WV, WY. Already allowed constitutional carry. Emergency ruling constitutionalizes approach, preventing future permit reimposition. What eliminated? Application fees, 50, 400. Training requirements, 4 18 hours, 100, 600. Fingerprinting, 25, 75. Character references, interviews. Processing delays, 2 to 12 months. Any government permission requirement. What states can still require? Instant background check at sale. Next. Prohibition of carry by prohibited persons. Restrictions in genuinely sensitive places. Schools, courthouses. Concealed versus open carry regulations cannot require permits for law-abiding citizens. Number 3, legal reasoning. Constitutional rights cannot be licensed. Analogy to First Amendment. Government cannot require permit to speak. Requiring government permission transforms right into privilege. Permit requirements are prior restraints. Prior restraint doctrine prohibits preventing exercise before determination. Specific exercise will cause harm. Permit systems are classic prior restraints. Fees create wealth-based deprivation. Application fees plus training, $175 total. Condition rights on payment. Citing Harper v. Virginia, 1966, striking down poll taxes, constitutional rights are not for sale. Training mandates are paternalistic. Government doesn't mandate training before citizens speak or practice religion. While training may be wise, government cannot mandate as condition of exercising right. Waiting periods deny rights when needed. Processing delays 2 to 12 months mean citizen facing immediate threat, stalking victim, domestic violence survivor, cannot exercise right when most urgently needed. Our constitutional right delayed is constitutional right denied. Number 4, state-by-state implications. California, 6 or 12-month backlog affecting 500,000 plus applications dissolved. All residents can carry concealed without permit starting May 13th. AB 2847 eliminated. State must refund fees. NY, NJ, MA, CCIA, and similar laws struck down. Residents can carry concealed without permits. States must refund fees. Illinois, CCL requirement eliminated. Residents can carry concealed without license. Blue states options. Can no longer require permits. Can conduct instant nice CS at sale. Can prohibit in sensitive places. Can regulate open versus concealed. Cannot mandate training for constitutional carry within state. Red states protected. 29 constitutional carry states have federal constitutional protection, preventing future permit reimposition if political control changes. Number 5, what gun owners should do. Effective date, May 13th, 2026. If you live in state that previously required permit, CA, NY, NJ, MA, CT, RI, MD, DE, HIIL, MN, or WA, MI, CO, NM, NV, you can carry concealed starting May 13th without permit. What remains prohibited? Cannot carry if prohibited person, felon, domestic abuser, mentally adjudicated. Cannot carry in sensitive places, schools, courthouses, government buildings. Businesses can prohibit on private property. Enforcement is trespass, not criminal. If law-abiding citizen not in prohibited location can carry concealed without permit. Purchase firearm. Must pass NICE's background check when purchasing from FFL. Once lawfully possess, can carry without additional permission. Choose carry method. Concealed versus open regulations vary by state. Most require concealed. Check state's requirements. Invest in quality holster ensuring retention and safety. Get voluntary training. While government cannot mandate, responsible gun owners should seek professional instruction. Learn safety, use of force laws, de-escalation, marksmanship. Understand use of force laws, no state's self-defense laws, duty to retreat versus stand your ground, castle doctrine, when deadly force justified. Consult attorneys specializing in self-defense law. Consider carry insurance. USCCA, CCW, safe offer legal defense insurance covering attorney fees if involved in self-defense incident. Pending applications, if you applied and paid fees before ruling, demand refund from state. File complaint with Attorney General if denied. Interstate travel. Ruling establishes constitutional carry as federal floor. But states may not recognize out-of-state residents' right. Research destination states' laws before traveling. Monitor state resistance. Some states may resist. Document any arrests for permitless carry. Contact Second Amendment organizations, FPC, SAF, GOA, immediately. Officials defying Supreme Court may face federal civil rights liability. Bottom line, Supreme Court emergency ruling, May 12, 2026, eliminates gun permit requirements nationwide. Core holding. Second Amendment protects pre-existing constitutional right that cannot be conditioned on government-issued permit. Any permit requirement, even shall issue, constitutes unconstitutional prior restraint. Constitutional carry is federal constitutional standard. Justice Alito. Constitutional rights cannot be licensed. Why? 6-3. Conservative majority held permit requirements unconstitutional. Liberal justices dissented, arguing states should be allowed objective shall issue permits. Majority rejected. Constitutional rights cannot be licensed, even through objective system. Permit systems eliminated. Shall issue states, CA, NY, NJ, MA, CT, RI, MD, DE, HI, IL, MN, and OR, WA, MI, CO, NM, NV. Permit requirements struck down. Permitless carry states, 29 states. Approach constitutionalized, preventing future permit reimposition. What eliminated? Application fees, 50, 400. Training requirements, 418 hours, 100, 600. Fingerprinting, 25, 75. Character references, interviews, processing delays, 2 to 12 months. Any government permission requirement. What states can still do? Instant background check at sale, NICS. Prohibit prohibited persons. Restrict genuinely sensitive places. Regulate concealed versus open. Cannot require permits for law-abiding citizens. Legal reasoning. Constitutional rights cannot be licensed. First Amendment analogy. Permit requirements are prior restraints. Fees create wealth-based deprivation. Poll tax analogy. Trading mandates are paternalistic. Waiting periods deny rights when needed most. Gun owners. Law effective May 13, 2026. Can carry concealed in states that previously required permits. Cannot carry if prohibited person or in sensitive places. Purchase firearm. Still need NICS check. Choose carry method. Get voluntary training. Learn use of force laws. Consider carry insurance. Demand refunds for pending applications. Research interstate travel. Monitor state resistance. Subscribe, because Supreme Court emergency ruling fundamentally transforms Second Amendment rights, and understanding constitutional carry nationwide determines how you immediately exercise your rights without government permission. Gun permits are over. Constitutional carry is now law of the land in all 50 states.